Hi everyone, today we're talking about trading under Phoenix Company. It's legally called a prohibited name, and I always take a very casual look at it, and it's not a casual subject at all. So my name is Bharkhada. What I'm going to tell you is going to save you if you've got a couple of companies that are of similar sounding names. It's a major risk when a company goes into liquidation. So the prohibited company in liquidation is really important to look at. It also turns into a criminal offence. When a company goes into liquidations, the directors face clear restrictions on what they can and can't do. This protects the public and prevents directors from simply restarting under the same name, leaving unpaid debts behind in an old company name. Using a restricted name without specific court permission is a serious criminal offence for directors under the Insolvency Act 1986. The liquidator and even vigilant creditors will closely monitor you as the director post your existing liquidation. So if you've knowingly hidden assets and obstructed the investigations and acted as a director of a new company with a similar sounding name, then trust me, there will be trouble. It will immediately trigger criminal prosecution, placing your freedom into jeopardy. Let's navigate this safely. So to protect yourself and to stay on the right track of the law, here's what you must do. Understand the name restrictions. Be fully aware of the limitations on using similar company names after your company goes into liquidation. Take legal advice. Talk to me. Get expert advice on whether a proposed new company name is going to be restricted or not. Make an application to court. We can help with that for the permission to use that company name. So make it justifiable rather than getting into trouble later. Ensure you act in a compliant way. Adhere strictly to rules with specific legislation on your side. Avoiding these things that I'm about to tell you will be much safer. These actions carry severe legal repercussions and are an absolute no-no. You must never act under a prohibited name without taking legal advice. You must never serve as a director or managing a company that uses a restricted name without court permission. It's a crime under Section 216 of the Insolvency Act. Don't provide misleading information, especially when obtaining credit or obtaining a new company if you're in breach of these regulations already. Don't attempt to bypass the rules. Do not use complex structures or third parties to manage a company under a prohibited name. Don't ignore these risks. Do not dismiss the dangers if you're involved in a new business using a similar name that you've already used before where a company's gone into liquidation. Trading under these restricted names will be significant. You face the very real danger of a criminal conviction, so please be careful. You could also have a personal director's ban and personal penalty of paying something significant. So I hope that this has provided some clarity. At Navigate Business Recovery, we work with directors every day to help them take back control of their company. Speak to us if you need confidential discussions as soon as possible.